Hearing in the appeal Robinson against Chief Constable, West Yorkshire Police.
Yes, Mr. Bell.
Good morning, my lady. Good morning, my lords. As you know, I appear with Mr. Lima and Mr. Fairgrieve, or Dr. Fairgrieve, for Mrs. Robinson, and my learned friends, Mr. Jeremy Johnson, QC, and Ian Skelt, Counsel Act for the Chief Constable of West Yorkshire Police. The facts of this case, my lord and my lady, I'm obviously not going to spend very much time on, save to tell you for your note that you find them at MS 44 of the core volume in the Statement of Facts and Issues. The only, just very, very rapidly, because I'm very aware I only have 2 hours to cover quite a lot of ground. So if at any stage I'm going too slowly, please speed me up, but I'll try not to go too quickly. The essential facts, I just read in paragraph 1, the incident occurred on the 29th of July 2008. We all know what happened as a combination of the arrest, the chasing police, the attempt to escape, and the contact with Mrs. Robinson, physically first, I think, from the drug dealer, Mr. Williams, but propelled, as we understand it, by the motion of force from the officers.
Well, is that's not? Does that appear? I thought it was Mr. Williams effectively pulling the officers. I mean, are we supposed to have looked at the CD we were sent?
At the
CD.
DVD.
well, at some stage, it would be sensible, I think, probably to look at it. But you see from the stills, I'll come to that.
I'm the only member of the court who has so far, I think.
Looked at the video.
Yes.
Yeah, well, it would be, I think, quite a good idea for you all to look at that at some
wanted
stage.
to know what you wanted us to do with it.
Yes.
Well, it's not very
Before
long.
doing anything.
Before looking at
It's not very long, but we do have in the call volume the stills, and I don't want to get stuck on that at this stage because I will come to that. Because I do see, obviously, we are very well aware of the distinction here of whether or not we're going to be, somebody might be saying, well, this is all to do with the criminality. Or we're saying it's all to do with the creation of the danger, but I don't want to get ahead of myself.
As far as the facts are concerned, paragraph 9, I think, is the agreed statement as to what created the momentum to impact on the appellant.
Yeah, you're looking at the Statement of Facts and Issues.
Yes, MS 46.
Yeah.
And the penultimate sentence that I was putting to you, really. Penultimate, perhaps the one before that as well.
There seems to me to be I've written in after paragraph 9 of the SFI, and what happened next? Because it doesn't actually say anything about your client being injured.
Well, I was
How
just
it
going to come to that. What? Yes, there was a bit of a mystery as far as we were concerned because we weren't acting below as to what happened. She was 75 at the time. Of course, now I think is 84. Soft tissue damage to shoulder, left elbow, ribs, bruising to shin and foot, subsequent cellulitis. She unfortunately already had COPD, chronic obstructive pulmonary disease. That was aggravated to the tune of 20%. This is all in a medical report. Immobile for 10 days following the incident, 2 months to regain full mobility, 6 months until she could return to her own house to care for herself. So it's a significant event.
But what paragraph 9 does not say is who came into contact.
Right. How she came to the ground.
How she came to fall to the ground.
It took the three of them to where she was, and from the photos, they all landed on top of her.
Yeah. Well, what happened, as I understand it, is you're supposed to have the pincer movement, the 2 officers coming from one end, 2 from the other. There are various findings of fact and there are issues, and that's what I'm going to give you some 8 propositions in a moment. And I really don't want to get stuck on breach and findings of fact just at this stage because I've got so much more to talk about.
We do have a findings of a recorder, of course. I mean, paragraph 1 of the recorder's judgment tells us what he found.
What we without please forgive me not wanting to engage with the detail of this quite at this stage. If you want me to, I'm very happy to, but I'm just
No, do things in your own order. Don't let us take you.
Just, yeah, I know it's not.
I just wanted to point out there was a noticeable gap in the agreed
Yeah, I'd love to say, can we do questions at the end? But the position is, two officers came from one direction, two from the other. There's a delay, and that's subject to the findings of fact and subject to comment by the Court of Appeal. They anticipate and foresee the risk of escape. They accept that had they noticed Mrs. Robinson, they would have walked on by. They had taken a decision at a slightly earlier stage that it was too risky to arrest him in the betting shop. So they were very well aware and accepted effectively a duty, in a non-legal sense, just for a moment, to be aware of the risk, the foreseeable risk to people immediately in the vicinity. Even the vicinity is slightly a broader concept than necessary for my case, because Mrs. Robinson was literally feet away, a second or two away from the first contact. The two officers, DS Willen and another officer whose name I can't remember, go to grab. They must identify themselves as police officers, start the arrest process. He then kicks off. There's then a melee. They have him momentarily under control. He slips away. He's a young, strong guy, one assumes. They follow him. You see this in the stills. As we're there, if I could just identify, you've probably seen them. But if you look at the pictures at call volume, they start at... Is it easier if I just give you MS numbers? MS 246 onwards. You can see the relevant ones are from 256. Or in fact, if we start at 253. So if you go to 253, page 118 of the call volume, you see Mrs. Robinson, the lady in white, walking up through the middle, just above Marketplace. So there she is. We have on the right, Williams's girlfriend in the black top, Williams to the left. And there are timings. Top right-hand corner, you can see the seconds ticking away. 29th of July, 8:15, 53 minutes past 3, 24 seconds. 2 seconds later,
10 to 4.
She's passing Mr. Williams, 254. 1 second later, she's passed Mr. Williams, and he's turned around and he appears to be looking in her direction. 256, he's turning to the left. I think these stills are all taken off. They're picked from the CCTV that you have. Then that's 28. Then still at 28, so still there, we see the first officer, broad chap with the white T-shirt. And then we see a sort of the shoulder movement there on the left. On the right, you see they appear to be moving quickly. That's 258. That's 1 second later, 29 minutes past, or 29 seconds past and 53 minutes. And then you see they appear to be, there's some 1 second later, there must be a verbal there, but I'd have to check precisely what the findings of fact are there. 259. They then go for him, 260. They grab him, you can see right hand on right shoulder. They start to wrestle. And we are still, I mean, this is just 1 or 2 seconds later, now 31 seconds. You see the bear hug at 262.
Well, by now he's moved away, hasn't he?
He has now moved away, but there's no doubt.
Dragged them down, yeah.
Yeah, there's no doubt at all.
Trying to push him on 256.
They're very close to Mrs. Robinson.
Against the wall, yeah.
But if you go back to 260, you can see how close she is. I mean, it's probably a little deceptive there.
Well, you can't.
It doesn't, not a huge amount turns on this. But we have a finding of fact that had I noticed her, I would have walked on by. I mean, that's a crucial finding. They then are pushing him effectively. I mean, they are the motive force. Of course, there's a mixed cause here. If he had just stood there silently and accepted his medicine, this would never have happened. But equally, had they not engaged, it also would never have happened. You see the girlfriend beginning to move there at the foot of 262, and then the crucial moment, 32 seconds passed and 33 seconds passed. I'm flicking from 262 to 263, and you see poor old Mrs. Robinson. I mean, it really is a pretty horrendous event.
Yeah.
She's not even expecting it. She is. They come at her from behind as a result of the decision to arrest, and you see them there. I mean, it's entirely self-explanatory. You can see a knee of an officer, which appears to be either on or very connected to Mrs. Robinson, and then, of course, Mr. Williams himself, actually on top of her. The officers were about 15 stone apiece. I don't know how heavy the young drug dealer was, probably not quite so heavy, but nonetheless, Mrs. Robinson was not in the best of health, and she was...
And but the chap who's standing is one of the other officers who's just...
Yeah, oh, sorry, forgive me. Yeah.
Two of them, actually, we can see two of the other officers.
Yeah. So the absence in all the other pictures we've looked at, you don't have the two other officers, the duo coming to meet them. Yeah. And that was the subject of, or rather the criticism and the finding of negligence at first instance by Mr. Recorder Pym.
They're first seen in 263, are they? Is that right or not?
Yes.
Yeah.
Well, you might see a leg in 262, I think.
Right.
To the right of her head.
Oh, got it.
Here's a leg, yeah.
But they're not there now. If they were there, had it been executed properly, they probably would have got him in one go. But this is all, in my respectful submission, and I do need to move on in a moment, a bit of a red herring, because the finding of the Court of Appeal was that it would be strange indeed if liability turned on who made the first contact, on who touched whom. I mean, that is, somebody will give me the reference, and it'll be, I do have a long speaking note, which I'm not going to hand up at this stage, but everything I say, almost a complete script, I have in due course if you desire it and to save you writing. So that's more than I intended to say at this stage of the facts. The issues identified in the SFI, paragraph 28, MS 52, were not terribly illuminating, and we both jointly apologise for that. There was a desire at that stage, certainly as far as Mr. Johnson was concerned, to keep the issue general. So therefore you won't find much help in the SFI. In our case, we identified three issues. The first, well, there's paragraph 4 of our written case. Scope of the emissions principle, which I'll obviously go to Michael. That is now the acknowledged backbone of the core rule in Hill. That's what we say. That's the general rule. And of course, we have 3 of the Constitution in Michael sitting on this panel, so I don't anticipate that. I understand it was a split court, of course, but we will be saying, we're sticking firmly to Lord Toulson's analysis. And I'm not trying, I am really, I promise you, not trying to refight battles that we have already brought to this court. So that's the first issue. That's essentially about the content and the ambit of the general rule. Is that rule limited to cases of pure emissions? And we say this is not an emissions case. This is a positive act case, a creation of a danger case, Rigby, Capellan and counties, and lots of other examples that we'll give you. Or does the general rule mean that it still covers negligent positive acts, and where does this case fall in terms of a chain of acts and omissions? So that was the first issue. The second issue, how in the light of Michael should the general rule be applied in the lower courts? That would involve looking at previous cases. And then 3, what are the parameters of the exceptions to the emissions principle? Assumption of responsibility, control, that's all about Couch, and Lord Toulson wrote at some length about that. And we add to that a third exception, which we get directly from Lord Goffin, Smith and Littlewoods, which is the creation...
Does any of that arise in this case?
The creation of a danger does, yes, absolutely, yeah. Now, that's very important to our argument. And we say we don't need to get there because this is not an omissions case. This
That's
is a
what I
positive,
thought you said,
This is a
yes.
positive act case. So, no, absolutely. I mean, I don't, that is, I suppose, maybe that's almost possibly by way of reply. But we say this is not an omissions case. Mr. Johnson, in his written case, says it is an omissions case. He takes a pleading point, makes various points about why it's an omissions case. He says this is a failure to act. And if we're right about, his point is, if you're right about the general rule, then you're caught anyway because this is omissions. We say wrong. It's a positive act case. But if we are wrong and it is an omissions case, we say we are within an accepted, acknowledged exception to the omissions principle, which, albeit is not mentioned by Lord Toulson in Michael, is very much part of the law. The academic commentaries on Michael have specifically stated Lord Toulson did not mention the third acknowledged exception. That was because, of course, in the Joanna Michael case, that was a pure third-party case, just like Hill, just like Smith Van Colley, where there was deliberate, cynical, criminal damage done to a human being, which was, it was found ultimately beyond the control of the police. So the reason that the third exception was not in play in Michael was because we predominantly, as the claimants in that case, our major point was assumption of responsibility, but we did then get dragged into the whole question of having another look at Hill because of the position of the intervener.
And what you're labelling your third acknowledged exception is control?
Is the
creation of danger.
Creation of a danger. And I'll come to that. Well, I give you the reference to that, my lord, just while we're on it. Lord Gough, Smith and Littlewoods, Volume 4, Tab 37, MS 1474 to 1475, for completeness, Law Report 272H to 273D. That's where you'll find that. So I'm still on the issues as in the core volume, or and then the third issue was they were three separate issues and they all went to breach. Now we've developed that inevitably as the case has gone on, and we now give you 8 propositions, which I will hand up in writing in due course, but they're as follows. Proposition 1 is the orthodox principles of tort law recognize that an individual owes a duty of care not to cause physical injury to others, which is a reasonably foreseeable consequence of their positive acts. We say that's a very uncontroversial statement for which there is multiple case law and authorities, some of which we'll give you. That we marry up with Proposition 2, which is the scope of duty that we contend for on this appeal. And that is that police officers owe the following duty: the duty of care at common law to take reasonable steps to ensure that during the arrest of an individual suspected of a criminal offence, foreseeable, and I underline physical, injury is not caused by the positive acts of the police to an innocent bystander or passerby who is caught up in the immediacy of the arrest.
Do they owe a duty of care to the arrestee?
No. I don't need to say that. The arrestee has remedies in the ordinary laws of tort, battery. Almost every case of a suspect being damaged would be assault, unreasonable force, assault, battery, I suppose conceivably misfeasance in public office, false imprisonment, unlawful arrest. There's a whole phalanx of causes of action that assist the Mr. Williamses of this world. There could have been a cause of action for Mrs. Robinson by way of sort of negligent trespass, unintentional assault. There's a quizzical look from my Lord Hughes. That was argued in one way or another. Assault was up at both levels, both at the Recorder PIM level and in the Court of Appeal. We also had a very good go at trying to get it before your lordships, because there are some very interesting cases. There's some Northern Irish cases about soldiers shooting target A, the bullet going through him and hitting target B. I can't now quite remember the nuances of the case law, but we thought that we had quite a decent argument that there might actually be a cause of action for Mrs. Robinson in some form of trespass case, but your lordships didn't want to take that. So there is quite clearly here a major gap, we say, in the law. I'm not asking you at all to expand the law of negligence in some novel, wholly new way. Our case depends entirely on established principles of law and adopts and embraces the reaffirmation of common law principles, which is what Lord Toulson and his brethren, forgive me, my lady, on the majority side, were saying in Michael, that we don't look at policy, we don't look at Caparo. What we do is we apply acknowledged principles, omissions, the third-party rule, etc. And that's all I'm saying here.
What is the shortfall, what is the inadequacy of the criminal injuries compensation scheme in this context that makes you wish to establish a common law duty of negligence?
That is an alternative remedy, I accept, but it's not a suitable alternative remedy.
Why is it not suitable?
Because you can't get full, proper compensation pursuant to the CICA or the CICB.
What's the shortfall? I mean, is it huge?
Well, there needs to be. I mean, what would have happened if Mrs. Robinson had a much more serious injury?
Yeah, but I mean, the point I fully see and sympathise with her position, and clearly one would hope that a civilised society provided compensation, but that it should depend upon precise analysis of whether police have been, quote, negligent, seems to expend a lot of resources and time on all sides in establishing something that one would hope wasn't necessary to establish at all.
Well, I mean, I think probably...
You can't help us to the precise...
Yeah, I mean, quick answer given to me by Mr. Fairgrieve is that this was a problem specifically caused, we say, by the police. They created a danger. I mean, I'll get into all of it.
You're not facing the point I put, anyway. It doesn't matter.
Yes, there's 2 points that you can make. One is you'd have to establish, would you not, a criminal act on the part of the arrestee. And secondly, you'd be concerned about the level of compensation.
Yeah, well, I adopt that.
I mean, there was clearly, one would have thought there was clearly a criminal act. He was wrongfully evading arrest, resisting arrest.
Caused entirely by the decision, the level of control.
No, that can't be right. Anyway, let's not.
I think we're going to get distracted
Yeah.
by looking at the criminal injuries compensation scheme, because there are lots of things you have to prove in order to get an award out of that, and we don't want to distract ourselves from
and I confess,
what we have.
If you, I'm sorry if my answer isn't sufficient.
From my point, it has a certain relevance if one's considering public policy aspects to this, which at some point one might be.
Well, we say you don't get into policy, and that's a core part. But if I could just proceed with my...
We've got to proposition 2.
Yes.
Got 6 to go.
I've done proposition 2. I'll speed up. Right, proposition 3. The case falls into a category of cases which already include multiple cases establishing that individuals and public authorities owe a duty of care in precisely the terms of my first proposition, i.e. not to cause physical injury to others, which is a reasonable foreseeable consequence of their positive acts. And then there is a subset of that wide category, which are outside the general rule in Hill, being that where the police create a source of the danger, they will be liable for any reasonably foreseeable damage, including where the damage is caused by a third party. That's my third proposition. My fourth is that, and I've made some of these points already in debate as I've gone, in Michael, Lord Toulson adopted incrementalism to the duty of care issue, not the policy-based Caparo approach. The approach that should have been adopted in this case is that, there was no basis to apply the three-stage Caparo test, a test which we say respectfully was misunderstood and misapplied by the Court of Appeal, as it only applies to novel cases. This case was not novel, and for those reasons they should have found that a duty was owed, i.e. incrementally. Proposition 5, and this is an important one for us, the general rule did not apply in Robinson, as it only protects the police from suit in negligence when they are accused of failing to protect life, limb, or property from third-party damage. And we are clear that reaching this conclusion does not require the court to depart from the ratio of any of the previous milestone decisions at apex level. Proposition 6, the justification for the general rule is the long-standing common law principle that there's no liability for omissions. Proposition 7 is broken up into 3 constituent parts. This case is not a pure omissions case. It's therefore outside the general rule. The correct approach was therefore to apply the incremental approach and fit it into the established category or categories already established under my third proposition, the broad one, 3.1, and the subset 3.2. If, however, contrary to that primary case, it is seen as an omissions case and covered by the general rule, we don't need to get there, I've already covered that with Milady, then this is an exception to that principle under either the control exception and stroke or the creation of danger exception. And then finally, as the third limb to Proposition 7, if the incremental approach cannot establish liability, as nobody can find an analogous case, or there is no case that's rejected a duty of care, that's Mr. Johnson's reverse incrementalism, then and only then does it qualify as novel, and only then do you go to Caparo and discuss policy. And that, we say, is a completely standard tort analysis, which is the tort analysis adopted by this court in Michael, and on a proper review and analysis of many of the previous cases that have been misunderstood and misapplied Hill by putting Hill widely to cover pretty much everything that a police officer or a police force does in relation to suppression and investigation of crime, leads to a disproportionate, all-powerful trump card, which has become extremely controversial over the years, has led to multiple cases which have no inherent coherence, complete failure at almost every level in the past to, for instance, explain Rigby. And that's in a nutshell what we say on the general rule and how it breaks down into Proposition 6 and Proposition 7. And then Proposition 8...
Can I just mention before we leave that, sorry. If we're looking at analogous cases, there's a large body of case law concerned with driving.
Yeah.
And police cars responding to emergency calls and so forth. It's not really discussed in the written arguments, and I don't think we have very many of the authorities in the bundles.
We have some of them.
We may have to look at that.
Yeah, we have some of them. We have an explanation for that. And just I could do that now very briefly, just in case I run out of time. There is no difference in imposing liability on a police officer for a decision when he is tootling along through Dulwich Village, as one of the cases involves a crossroads in Dulwich where my children went to school, so it means something to me. And he gets a call saying, emergency, rush to Camberwell or wherever it happens to be. He is then, there's a liability imposed on him for a judgment call that he has to make at that stage. How fast do I drive? Do I drive at 80 miles an hour through a crowded area? Or do I just tootle along because I know that I'm going to be the defensive argument. I'm going to be sued if it all goes wrong. There is absolutely no conceptual, analytical, legal difference, in truth, between a driving case and a Rigby case, or a driving case and an arrest case. Those are all examples, very clear examples, my lords, my lady, of a police officer actively involved in a core activity of suppressing crime. The first thing you do as an officer before you investigate something is you have to get to the scene. If there's a murder, you've got to get there quickly. But the law gives no protection at all to the poor Mrs. Robinson who is killed on the pavement because they lose control when they go around the bend. So no difference.
Well, there's certainly no immunity. A duty of care is owed. Yeah. But the content of the duty, what standard of driving is actually required, might vary according to the circumstances, whether you're tootling on a patrol through Dulwich Village or trying to get a stabbing victim to hospital before he bleeds to death.
You're absolutely right, my lord. And extending the ambit or the existence and ambit of a duty into cases like this does nothing other than provide a potential remedy in a proper case. There is complete protection for the professional officer through the ordinary position on standard of care and breach of duty. And the driving cases, I've read through some of them, not all of them, they make that point time and again.
You said, but the law gives no protection at all to poor Mrs. Robinson on the pavement, but I think you're saying the opposite. You're saying that it's perfectly standard as liability.
Forgive me.
Or were you sardonically explaining the other side's
Absolutely
position?
right. If there is to be coherence,
yes.
what I should have said, if there is to be coherence, then, and Mrs. Robinson is not to have a remedy, then equally Mrs. Robinson's grandson killed on the way to school by a speeding police officer. Also, there should be no duty in that case.
Can you just identify the cases which you've been referring to in answer?
I can. I will get to that. That's proposition 3.
Yeah. I mean, that's reflected in that context, if I remember correctly, by an exemption under the law which permits police officers to break speed limits.
Yeah. What, in the criminal law?
Yeah.
Oh, that I know nothing about. The 3 that we've got, I'm afraid we've got Marshall and Osmond, relevant paragraph 86, volume 3, tab 26. I'm afraid I don't have an MS number yet. Keyser, K-E-Y-S-E, another driving case, paragraph 87. Oh, sorry, did I just say? Marshall and Osmond, paragraph 86, 326. Keyser, K-E-Y-S-E, para 87, volume 3, tab 21. MacLeod, strangely, they're all the same paragraph numbers. Paragraph 88, another driving case. I've listed that, but I don't think it's in the bundle, so we'll have to get you that. And then there are some older driving cases which are referred to, I think particularly from memory, in Marshall and Osmond. So most of the jurisprudence you've already got, but we'll check that and make sure that you've got the rest. So that takes me then to the detail of Proposition 1 and 2.
Have we had Proposition 8 yet?
No. Proposition 8, yeah. Proposition 8, right. Assuming a duty of care, our position on breach is, 1, that despite expressing reservations in relation to the trial judge's approach to the evidence and the conclusion, the Court of Appeal, forgive me, it's not terribly well worded. Despite expressing reservations in relation to Recorder Pym's approach, both to the evidence and to his conclusions, we say the Court of Appeal did not actually interfere with his findings. So they didn't overturn the judge at first instance. And there, of course, we have a disagreement with Mr. Johnson. Alternatively, if we're wrong on that, and if the Court of Appeal did interfere, there was no proper basis for the court to do so. And we've got several authorities, one of which is a fairly recent one of the Lord Reed, in relation to how important the actual seeing the witnesses and the trial process was to the findings, and whether or not the Court of Appeal were in a position to overturn the judge. And we say if that did happen, it was an improper exercise of the appellate jurisdiction. So I'm now on to Proposition 1 and 2, and in support of the duty, we set out our argument in the case from paragraph 6 onwards, MS 57. I won't repeat that. You've got that. You probably read it already, but will do, I'm sure, in due course. My plan is to take you through 6 authorities in support, but it may be that if you are with me on the basic proposition, I don't need to go to all of them, and I'll just give you references. The first, of course, is Michael, Volume 1, Tab 6, MS 408. The second is Perrott and Collins, Volume 4, Tab 33, MS 1340. A case then affirming the principles set out by Lord Justice Hobhouse, as he then was in Perrott, is a Privy Council case, judgment of Lord Hoffman, called, I think it's Sudhar, against the Natural Environment Research Council, and that you find in the supplementary bundle at tab 77. A short section from Caparo, Volume 2, Tab 11, MS 547. Paragraph 17 of Gorringe, Volume 2, Tab 14, MS 702. Then 3 extracts from the academics: Winfield and Jolowitz, Volume 8, Tab 69. And then 2 very, very full and relevant articles. One by an academic called Dr. Craig Pursehouse, which is a detailed analysis and comparison between Robinson and Michael. And that's at Volume 8, Tab 74, and I would ask you to read that article very carefully. And then a case comment by a very well-known tort expert, who in fact I think is also one of the editors of Winfield, a chap called James Goodcamp. And that's a...
Goudcamp.
Goudcamp. A Revolution in Duty of Care, Volume 8, Tab 73, MS 2660. And it's not in that article, but in another one, I think either by him or somebody else, which we don't have, but we can get you, is they describe Michael and the way that the majority approach the question of duty. They rank it as one of the in the top 5 most important cases. It's sort of up there with Donoghue and Stevenson and Caparo. That's what the boffins are saying about your jurisprudence, my lords, my lady.
I see, incidentally, the case of Marshall addresses the question which my lady raised earlier as to whether a duty of care was owed by the officer to the person whom he's trying to arrest. And the answer given in Marshall was, yes, he does owe a duty of care if he's driving a car.
Well, Marshall was. It was the arrestee who was injured.
If he's driving a car. Oh, right, okay. But presumably not if he was just arresting him.
I don't think we'll make any such assumption. We will listen to your argument about your case.
Well, that's...
One thing that's clear from looking at the authorities is your paragraph numbering can be discarded. 86, 7 and 8.
Can it?
None of them seem to have paragraphs
But they
at
won't
all.
have paragraph numbers. They're far too old.
The reason that was a reference to the case, our written case in that case, where you will then find the relevant paragraph numbers. Do forgive me, a glitch. Probably not the first, or not the first, and almost certainly not the last. That takes me to Michael. One of the most notable aspects of the majority judgment has been said by the academic commentators to be the way that it has reasserted established principles of tort law over uncertain, unevidenced judicial intuition in this difficult area of the law. MS 440, tab 6 of volume 1. And I won't read it all out, but it's paragraph 115 to 116. And it's one of the most important paragraphs in the judgment. And he says that the refusal of the courts to impose a private law duty on the police to exercise reasonable care to safeguard victims or potential victims of crime does not involve giving special treatment to the police. But this is nothing to do with their status. It's consistent with the way in which the court has applied other authorities, has applied the same principle to other authorities vested with powers or duties to protect the public, and then the well-known cases, the regulation cases, the finance cases, UKNU, Davis and Radcliffe, the foundation building cases, Murphy, the road traffic emissions statutory duty cases, Stoven and Wise and Gorringe. All of those are all emissions cases. None of those are positive act cases. And what's happening here is Lord Toulson and the majority are depositing the general rule, or they are underpinning the general rule, explaining the general rule by reference to the emissions principle.
Are they explaining the general? One of the questions which we're going to have to face, I suspect, is whether they're explaining the general rule, if by that you mean the proposition which is generally derived from Hill, or whether they're providing an alternative basis for the absence of liability in cases where the complaint is that the police have failed to investigate and protect against the criminal act of somebody else.
Well, what we say, I mean, I'll come to this. I'd rather not get. That's a hugely important point, and I'll get there when we get to Proposition 5.
All right.
But just in a nutshell, we say it's now, given that Michael there was a general challenge to Michael. All of the jurisprudence was looked at in Michael. We had a vast amount of material, far too much, probably, that was put before you. There were 3 different liability solutions offered up to replace the rule in Hill. It was a comprehensive retreading of the general rule. And what came out of the end of the analysis was that Hill is all about third-party damage, a failure to confer benefits on somebody else, underpinned by the fact that there's no duty effectively to act in favour of another, although the famous examples of you can, unsatisfactory though it may or may not be, walk past a child in a drowning pond, no obligation to shout a warning to a man who's about to walk off the edge of a cliff. All of those famous examples, and I think they come from UKNU, I think Lord, can't remember now, Lord, well, had a memory lapse, but we can find where those examples come from. So at 116, the question is therefore not whether the police should have special immunity, but whether an exception should be made to the ordinary application of common law principles which would cover the facts of the present case. So we then need to look at paragraph 97, because it's at paragraph 97 that you find the justification, what I've just been saying about no liability for failure to control the actions of a third party, omissions, as MS 436. And then again at 98, we have here a reference to what I've already referred to as the exceptions, the 2 well-recognized types of situation, assumption of responsibility and control, to which I've already given you the references for my third, Lord Gough, Smith and Littlewood's creation of a danger. So this case, quite different. I think I've already said we apply the first proposition. Orthodox principles of tort law recognize that an individual owes a duty of care not to cause physical injury, etc., which is a reasonably foreseeable consequence of their positive acts. That is an equally important common law principle, which can rank really alongside, in terms of significance, the common law principle that was asserted in Michael. And that is what is in play in a case like this, and that is what underpins the liability for either carelessly causing or contributing towards physical damage. long established, not caught by the general rule. Yeah, and I've just been given, is that Mike, Michael? Yeah. Yeah, Michael, paragraph 97. Yeah, paragraph 97, which I think I've already referred to, but it's the passage just below G. It's one thing to require a person who embarks on an action which may harm others to exercise care. A person who embarks on an action, it's another matter to hold a person liable in damages for failing to prevent harm caused by someone else. So, what he was saying there, what Lord Tilson was saying there in 2015 wasn't new. He was really just in some respects winding back the clock to Hill itself. And what Lord Keith had made plain in Hill, which is that, and we get this from Hill at MS 280, 59C, that's volume 1, tab 1. There is no question that a police officer, like anyone else, may be liable in tort to a person who is injured as a direct result of his acts or omissions. So he may be liable in damages for assault, unlawful arrest, wrongful imprisonment, malicious prosecution, also negligence. Cites Knightley and Rigby. And then my note then goes on, in the same category we put the driving cases, damage caused directly by police in motor vehicle collisions, even when involved in the engagement in the suppression of crime. And then I have a reference there, which may already be to one of the actually, volume 8, tab 71. Yeah, that's an article by Paul Marshall, Police Liability and Negligence, the application of the Hill immunity in Australia. And there you will find a long analysis of Hill. I won't go into all of it now. It's MS 62616, fact situations falling outside the Hill principle. There are categories of cases in which the existence of a duty of care seems accepted, damage directly caused by police in motor vehicle collisions, even when engaged in what may be regarded as the suppression of crime, such as rushing to emergency. And then at footnote 108, we got some Australian jurisprudence, which we don't have for you, or pursuing a fleeing suspect, Schilling and Lenton, 1988, 47 SASR 88, and various other examples there as well. In addition, we have, to the driving cases, the firearms cases like Ashley, Jimenez, and the creation of danger cases, Capital and Counties, and Rigby. So in denying a duty in analogous cases like this one, the approach of the Court of Appeal and the respondent we respectfully submit is unprincipled, perpetuates uncertainty, illogicality, which has been a problem for many years, and is equally actually a fundamental attack on the orthodox principles of the common law. We can now say that with some confidence post Lord Toulson's majority decision. And it's a reassertion, as I've already said, of just a different category of case. In a case of physical damage like this, there is a different orthodox principle, i.e. Proposition 1. Then we've got the case comment by Mr. Goodcamp. I won't take you, I don't have time to, there are 6 points there that he makes. He makes the omissions point, says they're scathing about Caparo, MS 2662, majority deliberately avoided the concept of proximity, again the same page, 2662. Insofar as a general test for duty of care was utilised, it was incrementalism, 2663. I don't have to go anywhere near this territory, but he says that it foreshadows the downfall of Caparo itself. We don't say that. We say that Caparo has a perfectly proper role when properly understood and used not as an exclusive test, but as an exercise of expanding the law into new areas. And then finally, police not being treated differently to any other state agency. That takes me then to Perrott and Collins, volume 4, tab 33. And here we see a similar reaffirmation. In a completely different context, but it's there, the Court of Appeal doing really in many ways what Lord Toulson did in a PI case.
MS number?
MS number 1340,
One, three?
Volume 4, tab 33,
Yep.
MS 1340.
Yep.
Quick summary of the facts. Personal injury whilst travelling on a light aircraft. It crashes. First defendant builds it and flies it. Under a statutory scheme, it can only fly if it's inspected by the second defendant, who is an inspector acting on behalf of a non-profit-making organisation concerned with the advancement of amateur flying. That's the third defendant. So we've got D2 and D3. Case against D1 settled, and then it went ahead on a preliminary issue, I think, or a strikeout in terms of a duty of care being owed to effectively the third parties. It was a PI claim. And the allegation against the second and third defendants arose from negligence in failing to detect defects with the plane which led to the crash. Heard on a preliminary issue of law, succeeded at first instance, the defendants appealed, and the pro-liability decision at first instance was upheld by the Court of Appeal. The relevant passages, or first the relevant passage is at MS 1343 80E to F.
Sorry, 13.
80E to F, MS 1343.
Thank you.
And I'll read that out. When the second and third defendants seek to achieve, what they seek to achieve in this case is to extend decisions upon economic loss to cases of personal injury. It represents a fundamental attack on the principles of tortious liability for negligent conduct, which has caused foreseeable personal injury to others. That such a point should be considered to be even arguable shows how far some of the fundamental principles of the law of negligence have come to be eroded. The argument advanced in the present case illustrates the danger anticipated by Lord Lloyd in the final paragraph of his dissenting speech in Mark Rich. They also illustrate the dangers of substituting for clear criteria which are incapable of precise definition and involve what can only be described as an element of subjective assessment by the court. Such ultimately subjective assessments tend inevitably to lead to uncertainty and anomalies, which can be avoided by a more principled approach. That's exactly where we are in the police.
So what was being contended for the defendants there? Why did they say they weren't liable?
They weren't liable in that case because effectively of policy.
But what?
In a nutshell.
But what policy? I'm a regulator, therefore I shouldn't be liable for the consequences of getting it wrong. Is that it?
And it was, I think it was charitable as well. So.
Yes, one was a charity. They were acting in the public interest, I think, is probably the broad answer. So the quota, so it then goes on at ATF in fact, I've read that part. That deals with why Caparo doesn't apply. And then thus where a case fits into a category where the existence of a duty of care and a potential liability. Oh no, sorry, I've read that part. Do forgive me. All right. So then we get to history and principle at 1347. And at just below letter C, in the common law, there's always been a distinct category of liability for causing physical injury to the human body and to goods. And then a little lower down, the fundamental point remained the same, and the defendant had by some activity either caused either injury to the plaintiff's person or damage to his goods. It's the unreasonable conduct of the defendant causing foreseeable injury or damage, which provides the legal nexus between the defendant and the plaintiff and founds the liability of the one to the other. And then there's a reference to Lelivre and Gould, adopted by the House of Lords in Donoghue and Stevenson. Those cases are all about people and property. These are physical concepts arising from the physical consequences of the defendant's conduct. They do not relate to economic loss, though economic loss may come into account, etc. And then at 85D, he quotes Lord Oliver and Caparo, the infliction of physical injury to the person or property of another universally requires to be justified. The causing of economic loss does not. And at 86E, Lord Justice Hobhouse then goes on to address cases where no duty of care has been recognised, accepting that it's not a universal principle. And essentially you have to find proximity, and the proximity in all of these physical damage cases is that it's often just so obvious that there was a sufficient nexus, that frequently statements are made that mere foreseeability is required. Then at 86G to 87A, that's MS 349 to 50, the point that's made here with the passage beginning a minimum requirement is that though antecedent relationship is necessary as a matter of, as a concept, as a principle in the law of negligence, and also then in the same quote, nor has it been a requirement that the defendant should inflict the injury. So there he's saying that it's perfectly right and proper that you can have negligence claims when the injury is inflicted by a third party. And then at 87C, in cases of personal injury, it suffices that the activity of the defendant has given rise to the situation which has caused the injury to the plaintiff, where the defendant is involved in an activity which, if he is not careful, will create a foreseeable risk of personal injury to others. The defendant owes a duty of care to those others to act reasonably, having regard to the existence of that risk. The limiting factors are the concepts of foreseeability and reasonableness. So it's all about when you create a risk, you have a duty to reasonably manage it. You've created the situation, you're in control of what happens. And then 88E to 89B, MS 1351-2, where the plaintiff belongs to a class which either is or ought to be within the contemplation of the defendant, here Mrs. Robinson, by reason of his involvement in an activity which gives him and note the next word, measure of control over and responsibility for a situation which, if dangerous, will be liable to injure the plaintiff. The defendant is liable if, as a result of his unreasonable lack of care, he causes a situation to exist which does in fact cause the plaintiff injury. So that seems to be there a test which is not quite as demanding as the control exception that Lord Toulson talks about in terms of the exception to the omissions principle. And then over the page, or over my page at least, carrying on from that quote, once this proximity exists, it ceases to be material what form the unreasonable conduct takes. Now, I've taken that, I'm not sure if I'm right about this, but I think that is probably a reference to it, therefore doesn't matter who caused the injury, whether it's the defendant or the third party is responsible for the damage. And then examples of case law are then given, and then if picking it up just below the letter G at MS 1351, once the defendant has become involved in the activity which gives rise to the risk, he comes under the duty to act reasonably in all respects relevant to that risk. And this all fits perfectly with our facts, we say. Similarly, none of the particular difficulties which arise in relation to economic loss arise in relation to the causing of personal injury. He then states that once proximity is established, economic loss test in Caparo isn't applicable. And then we pick it up then just at the top of the next page, second line, page 89. Once proximity is established by reference to the tests which I've identified, none of the more sophisticated criteria which have been used in relation to allegations of liability for mere economic loss need to be applied in relation to personal injury, nor have they been in the decided cases. And in that case, although I don't think I've taken you specifically to the relevant passage, he specifically says Mark Rich, which has nothing at all to do with personal injury cases. Mark Rich was an essential building block of Lady Justice Hallett's analysis on the basis that Caparo applies across the board in every negligence case. That's a separate proposition. I can make the point quickly. I'll just make it quickly now. Mark Rich was a novel case, and all that Lord Steyn, or Lord Steyn, or Lord Justice Steyn, was saying in that case was that Caparo applies across the board to all types of damage in novel cases. We then have a case. I don't have time to take you.
Why was it a novel case there, Mark Rich?
Mark Rich, if you'll forgive, in order to answer that question, I'll need to take 5 minutes. I don't have 5 minutes. In a nutshell, it was because they were suing a classification society in novel circumstances. I've got all that on paper. If I got time, I'll go there. But it was essentially accepted by the judge that it was a novel claim.
No such claim had ever been made before.
No such claim had ever been made before against a classification society. So there is in my submission no doubt that Mark Rich was novel.
I'm not sure that's quite right, because I argued one at the bar before it. But
did he win or lose? Did he win or lose, my lord?
We settled it.
Well, there we go.
There you are.
I'm being told to move on by my team because I'm only on page 11 of a 72-page speaking note. Sudrahar, tab 11, supplementary bundle B. That confirms Perrott. It's pretty high authority, or very high authority. It's when I had the cheek to challenge in a recent case at first instance in front of Mr. Justice Jay, his subsequent decision referred to lèse majesté and having the temerity to challenge one of Lord Hoffman's pronouncements. All the pronouncements of both Lord Hoffman and Lord Brown in this case, paragraph 38.
Sorry, is this Sutradhar?
Yeah, Sudrahar, yeah. It's the Bangladeshi water case.
Yeah, it's in our volume 9.
It's volume 9 now.
And 77.
Tab 77.
They're both long quotes. When I hand the speaking note up at the end, you'll see them all there. But on fact, they got nowhere near Perrott and Collins because there was no control over poisoned water in Bangladesh. The class of victims that it was being suggested by the lawyers in that case and Lord Brennan was effective, according to Lord Brown, the entire population of Bangladesh. All I can say is if there was a case which is bound to fail at the proximity hurdle, this surely is it. Lord Brown talked about there was no particular transaction. The transaction in our case is the arrest. There was no control or responsibility for what happened. In Sudrahar, it was all about negligent misstatement and central government stating that something was probably safe when in fact there was a level of arsenic poisoning. But the important point is, I think picked up Lord Hoffman, paragraph 38, I'm afraid I don't have the MS number, where they talk in terms of needing a measure of control over dangerous situations. Now, insofar as that basic common law principle is established, then I don't really need to go any further than that, but I will give you the references. Winfield and Jolowitz, I've already given you the where you find it in the bundle, volume 8, tab 69. Paragraph 5-029, where the defendant has directly caused physical harm to the claimant or his property by an act, a duty may readily be established by showing foreseeability and nothing else. It's essentially the point is that it is the point is that it is self-evident in all of these cases that proximity exists. I'm prompted, I didn't make the point properly, that the point about Sudrahar is simply that Perrott is confirmed at apex level by the, so the test that I've gone through in some detail of Lord Justice Hobhouse is confirmed by Lord Hoffman. Then we have Caparo at 632C to G, such close and direct relations that the act complained of directly affects a person whom the person alleged to be bound to take care would be directly affected by his careless act. That's a quote from Lord Atkin, from Donoghue and Stevenson. And I'll just give you the references. It's Lord Oliver, 632C to G.
Where are you, please?
I'm at Caparo.
Which is where?
Which is volume 2, tab 11.
Thank you.
632C to G.
Have you an MS number?
574, yeah.
574.
574. And I won't go through that because of time.
You're in a hurry, Mr. Byrne, and I'm not trying to speed you up, but if you simply fire off quotes without saying where they are,
No.
we either listen but don't know where they are,
No.
we can't follow.
Yeah, no, I entirely accept that, and I have everything on paper which I will hand up to you.
I see.
At the end, or if you prefer, I could hand it up now, and you can follow it. Then Gorringe, Lord Hoffman, paragraph 17, MS 708, volume 2, tab 15, 1063F of the law report. And I'll just read halfway through the quote of paragraph 17. It is not sufficient that it might reasonably have foreseen that in the absence of such warnings, some road users might injure themselves or others. Reasonable foreseeability of physical injury is the standard criteria for determining the duty of care owed by people who undertake an activity which carries a risk of injury to others, but it's insufficient to justify the imposition of liability upon someone who simply does nothing, who neither creates the risk nor undertakes to do anything to avert it. And then I'll just give the references for the two articles where you will find exactly the same points made. One article I'm going to refer to is page 10 of the Per House article at volume 8, tab 74. And there he says, he rehearses the same material and says that it's odd indeed that Mark Rich was relied on, given what was said in Perrott. MS 26756.
2675, I take it.
2675 to
/6.
to 76. And then bringing that together, my submissions on 1 and 2, which I will rattle through. No need to consider if there's sufficient proximity in a particular case if a duty has been established in a like or analogous case, Perrott 86D. Conceded at paragraph 42 of Mr. Johnson's case, penultimate line MS 123 to 4, that it's not necessary for subsequent courts to consider the Caparo analysis. He seems to, I think we're at 1, that this was not a novel case, as I understand his argument. 2, we accept that proximity must still be established when a duty of care is said to exist to provide a remedy for reasonably foreseeable personal injury caused by a careless act, Perrott 86E, but it's there in almost all physical injury cases. The only requirement is the measure of control over and responsibility for a situation, paragraph 38 of Sudrahar, 88E of Perrott. Measure of control, responsibility for causing or contributing to the dangerous situation. That's what qualifies for the special circumstance or relationship which Mr. Johnson says is missing in this case. MS 109, paragraph 8 of his written case. So therefore, following Lord Toulson's lead, paras 115 to 116 of Michael, and applying orthodox principles, we say reasonable foreseeability, proximity, caused by a careless act of the police. Second limb, the police have involved themselves in a relevant activity which has given them sufficient control, responsibility over a dangerous situation, therefore proximity. We therefore, under those circumstances, don't need to go further, and we don't look at policy. I've covered this to an extent already. Findings of fact say they've not been overturned. See particularly SFI 13D to G, MS 47. Plainly show that the arresting officers realised there was significant risk to the public. They foresaw the danger. They had the requisite measure of control responsibility for what occurred.
And on your argument, it is immaterial that the immediate the danger to third parties is one which would be immediately triggered by the voluntary act of somebody other than the police officer.
You mean, if you're referring there to the decision to resist arrest?
Yeah, I mean,
We accept that was voluntary. Of course we accept that.
yes, and you say that's immaterial.
That's immaterial. But what is important is that the damage which is actually caused is not a deliberate act. So everything that your lordship discussed, and we rely on it in your decision in the Inner House in Mitchell, about the philosophy behind the law not imposing liability in third-party cases, the shifting of blame to the wrong party, somebody with only peripheral responsibility, all of that stuff.
Yeah.
That doesn't apply here. So it's not a third-party case in that sense.
Would it make a difference if the situation had been slightly different, the police hadn't been in contact with him, he was running away, the lady was in the way, and he'd struck her out of the way?
We accept that if he escapes and then gets a car, drives into somebody else, no liability.
Well, the example I gave was a little closer than that. He's running away, there she is, strikes her out of the
That's
way.
a deliberate act.
And therefore,
That's no liability.
no liability.
So, sorry, because he's committed a deliberate act, I mean, supposing he'd broken free and had just run into her and knocked her down.
Right.
I think that was more...
No, I was asking about a deliberate act, but I'm trying...
Always subject to
trying see
correction.
where the difference is.
I'm the mouthpiece. We've got the brains of the operation here on the left and right. So subject to them telling me that my answer was wrong, it seems to me that our case is a very narrowly drawn scope, and we accept there will always in these situations be a level of arbitrariness.
Well, there's always going to be a difficult line.
Line has to be drawn.
But the line you say is between accidental contact with her and deliberate contact.
Exactly.
I see.
I suppose,
Exactly.
does one draw the lines by applying conventional principles such as novus actus, for example?
Yes, and there is a whole argument about novus actus. There's Dorset Yacht on one side, there's Smith and Littlewoods and Mitchell on the other. I've got all the references for that. We say reasonable foreseeability is enough. Yeah. Creation of a danger, the reference I gave earlier on to Smith and Littlewoods, and crucially also, in fact, can we just get it up quickly? Where's Mitchell? Can you tell me where Mitchell is?
So if, for example, they were trying to arrest somebody who was wearing a suicide bomber who's wearing a pack of explosives,
Yeah.
and they're perfectly well aware of this. His trigger, his deciding to detonate himself, might not be viewed as a novus actus because that's precisely why they are trying to arrest this person before he does that. Wow. But if on the other hand he
Well, that's de Menezes. Those are the facts of de Menezes.
yeah.
And in fact, there is a decision, I'm not going to have time to go there, but I can tell you where it is. There is a whole analysis of Hill in the context of manslaughter by way of gross negligence in the inquest. And there's a very useful analysis of all of these cases, with the retired High Court judge ultimately saying there was a duty of care on these officers in terms of what happened to the poor old electrician. So in these firearm situations, in dangerous situations, there is often liability. And those cases are all cases within what my learned friend says and other judges have said is the extended understanding of Hill, which you don't find from Hill itself. You only find third-party failure to confer benefit logic from Hill. So what we are saying is we are simply trying to regulate and provide coherence by using Lord Toulson's analysis to say that all of the difficult areas, and I'm going to come on and look at Rigby and Calverley particularly in the time that I have, that once you understand that Hill is actually a narrow principle, which refers to omissions only, where you then go, you don't jump, as my learned friend, I say very understandably and forensically, but entirely impermissibly, says, well, all right, omissions, no liability. Positive acts, all the protection's gone. Well, that's nonsense. It hasn't gone at all, because it's tested by reference to the ordinary principles of negligence. and there you go. You don't go to Caparo, because this is such well-trod territory. You go incrementally, and you look at what's happened before. The law does not go forward in this area in leaps and bounds. We go crab-like from one situation to another. And I'm not having to act like a crab here, because many crabs have already crawled over this. And I'm being told to move on. Right, so enough.
How far do you push it? I mean, presumably, if he escapes from the initial arrest and runs around the corner, so the police are not there,
Yep.
and at that point he's running so fast he just runs negligently into someone and knocks them over and injures them, is a liability?
We're thinking about that one. I would have thought no liability.
I mean, it's a crowded city centre if one looks at the...
Well, it's the narrow duty which has to be related to the management and control of the risk.
So we've got to add something in, namely what, that it's got to be very close to the...
Well, I mean, I talked about immediacy, and I stick with the analysis that I have in Proposition 2.
Proximity, perhaps might be the word.
Yeah.
If you come into direct contact with people, proximity is there. But if it's not direct, you may have to have some other basis.
Right, yeah.
There's got to be proximate to the arrest.
Yeah.
And
I mean, obviously one can imagine all kinds of difficult factual situations which are on borderlines, but one has to resolve them applying the conventional tools of foreseeability, proximity, causation.
yes. Yes, and here, I mean, you get into the Lord Nichols line of jurisprudence, which we've seen in many cases. I mean, I don't have it before you, but Phelps is one that's ingrained on my memory, where it's the never say never question, which is then replicated, I think, I can see deep breaths there, but paragraph 6 of Brooks.
Well, there's a debate between Lord Hoffman, who likes to say never on occasions, and Lord Nichols, who almost invariably says never say never.
Yeah,
It's
okay.
an ongoing debate.
Yeah, and going into Proposition 5, there's said to be an exception to Hill. That's acceptable to some of the judges at this level, not to others. Paragraph 109, I think, of Lord Carswell in Smith says that it's acceptable. Lord Roger, in another case, I think said that it wasn't. But if I can move on, because I was going to, the rest of my submissions on this area relate to whether or not it was the criminal act or the activity of the police, and I think I can skip through all of that. And that takes me through then to Proposition 3, and I've only got, well, actually, I've got 40 minutes, 40 minutes, maybe a little longer left. So Proposition 3, just to remind you, that was, so here we're sort of moving into incrementalism. Multiple cases establishing that liability, that duties are owed to individuals and public authorities not to cause injury, as per Proposition 1, and then the subset that I've already described. And we find them, both police and non-police cases. In our written case, we've divided them up into third-party and non-third-party cases. Paragraphs 76 to 88, that's MS 79, MS 82. First example is Perrott and Collins, and I've dealt with that already, volume 4, tab 33, I would say no more about that. Second example, Dorset Yacht, volume 2, tab 16, and there are two references to Lord Diplock, both on MS 800, 1070D to E and 1070F, where Lord Diplock concluded that a duty to take reasonable care to prevent Borstal trainees escaping would only be owed by the custodian to a member of the public, where there was a relationship between the custodian and the claimant which exposed the claimant to a particular risk of damage, different in incident from the general risk of damage shared with other members of the public. And here we have a closer relationship between the police and Mrs. Robinson than we do surely between the Borstal boys and the officers who go have a go to the pub or wherever they went, leaving the boys to roam and to damage yachts in the vicinity. And then the 1070F, the distinctive added risk is the reasonably foreseeable risk of stealing or damaging properties situated in the vicinity of the place of detention from which he's escaped. And there we've got a finding in our favour there. They understood that there was a foreseeable risk of flight. Haynes and Harwood, we don't have in the bundle. There's a well-known case. That's the case of the, I think the horse and cart parked, the naughty boy throws the stone. It's negligently left in a busy place. Careers down the road, and a policeman is damaged trying to stop the horse. Summarised by Lord Gough in Smith and Littlewoods. I won't take you to it, but it's... well, actually, no, I will take you to it. Sorry, that's the 2728, Volume 4. Volume 4, MS 1474. Because this is important on Novus Actus. It's at the foot of the page, 2728H. These are all special cases. That's having referred to Dorset Yachts, Stansby and Trotman, Smith and Lewis. But there is a more general circumstance in which a defender may be held in negligence liable in negligence to the pursuer, although the immediate cause of the damage suffered by the pursuer is the deliberate wrongdoing of another. This may occur where the defender negligently causes or permits to be created a source of danger, and it's reasonably foreseeable that third parties may interfere with it and spark off the danger, thereby causing damage to persons in the position of the pursuer, and then Haynes and Harwood is referred to. There is another similar case, Donoghue and Stevens, not in the bundle, Grant against Australian knitting mills, very important, if only for the unforgettable line. I accept, of course, that there is no internationally recognised code governing the manufacture of underpants. If I have time, I'll go back to that, but it's unlikely that I will. Mobil Oil Hong Kong is the next case at Volume 9, tab 79, page 328. It's a reference to page 15 on the index of the supplement, which is wrong. And there at 328,
Internally.
156.
you're ahead of me. Page 79, sorry.
156.
All these references.
So tab 79, volume 9, page 328, that's MS 157. In most claims in respect to physical damage to property, the question of the existence of a duty of care does not give rise to any problems because it's self-evident that such a duty exists and the contrary view is unarguable. Typical examples are claims in respect of physical damage to property arising out of the driving of a motor vehicle on a road or the navigation of a ship in a river. With regard to the driving of a motor vehicle on a road, it's self-evident that the driver owes a duty of care to owners of other vehicles using the road to avoid damage, etc. Then we have capital and counties at volume 2, tab 12. That's in our written case at MS 70 to 71. And the relevant part of Lord Justice Stuart Smith's judgment, MS 633, 1031C, it's a long passage, C through to the next page, 1032B, and you can, if you pick it up just below the letter D, but where the Rescue Protective Service itself by negligence creates the danger which caused the plaintiff's injury, there is no doubt in our judgment the plaintiff can recover. There are many examples of this in Rigby against Chief Constable of Northamptonshire. The plaintiff's gun shop was at risk from a lunatic. The police came to deal with the situation. They fired a CS canister of gas into the shop, though it caused a high risk of fire without ensuring the fire engine, which had previously been available, was there to put out the fire that resulted. And then there's a reference to Knightley and Johns and Dorset Yacht. And then at the foot of the page, at H, these are all cases, however, when a new or different danger has been created from that which the police were seeking to guard against, except perhaps the Alcock case. A comparable situation would be if on arrival at the scene of a fire, the fire engine was negligently driven into the owner's car parked in the street. But it seems to us that there is no difference in principle if by some positive negligent act the rescuer or protective service substantially increases the risk, he is thereby creating a fresh danger, albeit of the same kind or of the same nature, namely fire. The judge held that at the time the sprinklers were turned off, the fire was being contained, but that once they were turned off, it spread rapidly. So that's capital and counties. And then we have Couch. Do I need to go to Couch? Couch, MS 97. It's in our written case at para 130 to 131. The relevant paragraph is 124, MS 2382.
Sorry, hang on.
MS 2382.
Yeah.
And then I'll just run through the police cases and give you the references. Rigby, paragraphs 44 to 51, 76 to 78 of our written case, MS 67 to 71. You find that again at volume 4, tab 34. Knightley and Johns, paragraph 76 to 77, MS 79, volume 3, tab 22. O'Dwyer, that's a giving a gun to a sort of lunatic police officer case. Quite an important case for us. Paragraph 79, MS 80, volume 4, tab 32. Attorney General of the British Virgin Islands against Hartwell.
Yeah, I thought you'd mention that.
Yeah, got there in the end. Volume 2, tab 9, our written case, paragraph 60, MS 73. An important case that I would certainly ask your lordships, my lady, to read, State of Victoria against Richards. It's quite similar. It's a Rigby-style case, analogous to this one. Paragraph 79, last 3 lines, and paragraphs 117 to 121. I think that may well be a reference to the paragraphs of the case itself.
What's the reference to that?
Another important case in the supplementary.
What's the reference to the State of Victoria case?
I'm sorry?
Did you give us a reference to it?
The reference
We'll
is
find it.
paragraph 79 of the case.
No, don't worry. MS.
Volume 6, tab 55. Then a case at tab 80 of the supplementary bundle called State of New South Wales against Tyzyk, or Tyzyk, Tyszzyk, and the relevant passage in that is at supplementary MS page number 184 through to 185, and it's the internal paragraph numbers of the law report at 119 through to 128. All of this is relevant, as we'll see subsequently, to Proposition 5. Ashley, Volume 2, tab 8. That's the Sussex case, the awful shooting of the man in the bed. Paragraph 83 of the written case. Kelly Nino against Paulello and the MPS, paragraph 84, another analogous case. Was that an arrest case? Yeah, demonstration at the Turkish embassy, an arrest case, decision of well-known High Court judge. Ida, Mr. Justice Ida, thank you, who decided, I think, the case on the basis of assault and battery, but made very clear that he would also equally have allowed the claim in negligence. That similar thing happened in the Ashley case, and that you find at volume 3, tab. I've got tab 20 here, but tab 19, I'm told. Then a coronial ruling I've mentioned in the Jimenez case, MS 1003 to 1009, and then MS 1014. The relevant, I'm a little confused by the paragraph numbers. I believe this is of the case itself. Paragraph 33 to 48, paragraph 61 and paragraph 85. Then we've got the driving cases I've already given you, and also we put Calverley on our side, whereas my learned friend relies on Calverley, and that's paragraph 74 to 75 of our case, Calverley, volume 2, tab 10. Now, the types of cases that are stopped by the general rule, so all of those cases are on our side. Positive act cases, not omissions. On the other side are Hill, to an extent, although not quite so much, Brooks, Smith, Van Col, and Michael. All of those cases are stopped by the general rule because there is a failure to confer a benefit. So those all fit within the Michael analysis, i.e. the police don't stop the murder, they don't manage to stop the rape or protect the woman. Various different fact situations are in play.
When you say failure to confer a benefit, should we understand that to mean failure to stop someone doing something criminal?
Exactly. Failure to control a criminal.
Failure to protect.
Precisely. Failure to act in favour of another. There are all of these phrases that are thrown around, but they essentially mean the same thing. There's no liability, there's no duty of care. It's all underpinned by the omissions principle. So the proper approach, we say, goes like this. 1, Hill is a rule denying liability in cases of pure omission. Toulson, 97 to 98, MS 436, 115, 116, MS 440. But that doesn't answer the question of whether the police will or will not be liable for a positive negligent positive act, or cases where there are omissions within a series. So you have acts and omissions. So you have mixed cases. And we tried to grapple with that in our written case. Therefore, the protection for the police from the consequences of negligence can extend to cases beyond pure omissions, but it doesn't depend upon the application of the rule in Hill. So our submission is that the law requires the judge in a case which is not a pure omissions case, first to search incrementally for analogous cases, and that goes back to Sutherland, Shires and Hayman, page 481, MS 1952. I'm afraid I don't have a volume number at the moment for that, and is repeated throughout the jurisprudence to Caparo itself and ending up with Michael. So if there are then no answers, because we can see, I think, to use one of Lord Toulson's phrases, that the law has not gone, where has the law gone or where has it refused to go, then you then go to Caparo, and then you go to the novel case or not. That takes me on, I'm delighted to say, to Proposition 4. Proposition 4, to remind you, is the Court of Appeal should have adopted an incremental approach in Mrs. Robinson's case. There is no basis to apply the three-stage Caparo test. A test misunderstood and misapplied by the Court of Appeal. It applies only to novel cases. This case was not novel. The result should have been that a duty was owed. The relevant paragraphs where you see the error are paragraphs 41. I've actually got 41 to 41 there, so I got a mistake. MS 148 to 9, I presume it's 41 to 42, where she decided that Caparo was a general and universal test or yardstick that must be applied in every negligence claim. And then under the heading applicability of the Caparo test for physical damage, oh, in fact, it's the same paragraph, MS 148. You can see it starts with second, the Caparo test applies to all claims, etc. And then on the fourth line, it's become part of the general law in the vast majority of claims. The answer to the question posed at the third stage of the test, whether it's fair, just, and reasonable to impose a duty, may be obvious, but it still applies. I can see no justification in the case law or the textbooks for restricting its application to the more difficult areas. Well, that's complete, with the greatest of respect, complete misunderstanding of Caparo. That analysis has been treated with condemned in the nicest possible way by the commentators, because it's, of course, in novel cases, it's in the difficult cases that you use Caparo. That's the whole point. So Miss Widdett, who was given a very hard time by, I haven't given you there were changes between the draft, the hand down, and the ultimate judgment that was given. She was right. In our respectful submission, she was quite right about Caparo. And the Court of Appeal did make a significant error. However, having said that, it's a significant error that has been made on other occasions by other judges and has been the subject of considerable comment and surprise by...
It's the fairness and reasonableness part of Caparo.
I'm sorry?
It's the fairness and reasonableness part of Caparo that you say is irrelevant, or the other way of putting it is that it's axiomatic.
Yes, of course, but of course, fairness, and what Lady Justice Hallett would probably say in her defence is, well, the fairness and the justice and the reasonableness get morphed into the two earlier stages, foreseeability and proximity. We know from Caparo itself, they are mere labels. It was never designed as a universal test. All of those authorities, all of the actual black letter law, when you read it, from what the judges actually said, is quite clear. If I just take you to a couple of, if I need to develop that further, I would give you the following references. I mean, it may be that I don't, because I'm not sure that there's. I think there might be unanimity here between.
Let's find out.
And my learned friend. Right, okay. I won't go through them for time reasons, but Lord Justice Hobhouse, 80E to F, 80D, 80G to 89A, Lord Lloyd and Mark Rich, 230C to D, all of those make the same point about Caparo not applying in this type of personal injury case where there has been damage caused, physical damage caused, personal injury caused by positive acts.
Have you an MS reference for the Mark Rich citation?
I think I do. MS 959.
What about the Hobhouse one?
That would be Perrott.
Perrott.
MS 1343.
We've already gone.
I want the MS reference. Just
Hobhouse, the three Hobhouse references, 1343,
yeah,
1349,
yeah,
1351,
yeah. Thanks.
Lord Lloyd 959. I've got them all in the speaking note, but I won't go through them. Goodcamp is, or Gaff, forgive me.
He's
Sorry, I'm sorry. I've never met him. I'm really sorry. I hope one day to meet him.
Well, he's a barrister. So
He's not very far away.
Case, he'll probably invite
Not very far away, Mr. Byrne. Anyway, never mind.
Volume 8, tab 73, a revelation in duty of care, MS 2660. That's where he really makes his point on Caparo. Similarly, the Purse House article, volume 8, tab 74, MS 2666, and at MS 2682, page 17, Lord Toulson stated, Well, just cutting to the chase on that, it may seem rather astonishing that the fact a judge has correctly reiterated the approach contained in a House of Lords decision, he's here talking about Lord Toulson, that has reflected the law for over 25 years is worthy of comment. But given the extent that academics and judges still mistakenly refer to Caparo as authority for a three-stage test by which all cases should or must be decided, this reiteration is necessary and welcome. If Lord Toulson's judgment corrects the false reading of Caparo, then it is a landmark opinion in its own right. And then the Mark Rich issue raised novel questions. The Lord Stain, I don't have a MS reference. Oh, I do. 236C, MS 965. I think I've already given you that, actually. Then Lord Stain's comment that the Caparo test applied to all cases was in response to an argument at MS 946, 216A, and MS 964, 235E, that the full Caparo analysis was applicable only to cases of pure economic loss, not to cases involving foreseeable physical damage. And that passage, which is relied upon, is only stating the uncontentious proposition that in novel cases, regardless of the type of injury, a full Caparo analysis is the proper approach, if novel. And then another passage, 236B to D, further supports the fact that Lord Stain was talking and very deeply aware of the incremental process. And that is the clearest indication that his comments, earlier comments at 235D to E, MS 964, which is what I think Lady Justice Hallett fixed on, was all about novel cases. And then the final nail in the coffin of this particular reliance by the Court of Appeal is Perrott and Collins at 135592G. Mark Rich should not be regarded as an authority which has a relevance to cases of personal injury, or as adding any requirements that an injured plaintiff do more than bring his case within established principles. If a plaintiff is attempting to establish some novel principle of liability, then the situation would be different, and the considerations discussed by Lord Stain could be relevant. Barrett and Enfield, 1998 QB 367, but that's not this case. So we say major error shows a understandable maybe, but regrettable misunderstanding of Caparo. This court needs to correct that as a matter of some importance. Proposition 5, the general rule did not apply as it only protects the police from suit in negligence when accused of failing to protect life, limb or property from third-party damage. Reaching this conclusion does not require the court to depart from the ratio of any previous decision. So I've already covered and given you the references for pure omissions. Michael, paragraphs 10 to 15 of the written case, MS 58 to 60, 31 to 41 of the written case, MS 63 to 65. I've already stated that the general rule itself was expressed in narrow terms by Lord Keith, Volume 1, Tab 1, MS 280, Lord Keith 59A to C. Question of law opened up by this case is whether the individual members of the police force, in the course of carrying out their functions of controlling and keeping down incidents of crime, that's a wide reference there, but then it's narrowed, and we look at the duty, owe a duty of care to individual members of the public who may, and I underline these words, suffer injury to person or property through the activities of criminals, such as to result in liability and damages on the ground of negligence to anyone who suffers such injury by reason of breach of duty. And then we see Lord Keith staying faithful to orthodox principles, no question that like anybody else they can be liable for direct acts, and I've looked at that already. So there were rival submissions in Michael. I won't take you through all those, but there was Lord Panic and Mr. Johnson saying it was a wide rule, suppression of crime, investigation of crime generally, and then I submitted that, in fact, the same submission that we're making here, that was a misunderstanding and a improper extension of Hill. We say that Lord Phillips at paragraph 97 of Smith and Van Col got it right, and that you find at volume 1, I think tab 4. I'm not going to have time. It's a long, we could spend a day just by itself, just going through all of the relevant references to the width or otherwise of hill. But you see at 97, you see Lord Phillips explaining, and this is one of the few clear statements of what the actual core rule is. And he's discussing Brooks and the famous reference to Lord Steyne confirming Hill, saying, if a case such as the Yorkshire Ripper, what came up again for decision today, I have no doubt at all it would be decided in the same way. And he was absolutely right. There's completely you can't put a Rizzler paper between us and the House of Lords, because we completely agree, as does Lord Toulson, as did the majority in Michael.
What Lord Phillips says at letter B on MS 377 is at the heart of this submission.
Exactly, and that's what we're asking.
The principle is, in the absence of special circumstances, the police owe no common law duty of care to protect individuals against harm caused by criminals.
That's it, that's my point. Yes. Your Lordship has the point. And that is what we are asking you to confirm once and for all, to settle this dispute as to the width of Hill, that Hill absolutely still survives, not as an immunity, but as a nuanced rule based on orthodox common law principles in exactly the terms set out there by Lord Phillips. It's, in some respects, what's been said in the past, if that's right, doesn't really matter, because it's been confirmed after a full review by Lord Phillips. But I'm going to spend a little time, a few minutes on Rigby. MS 1379, volume 4, tab 34. MS 1379 is the beginning of Rigby. It's a siege, it's an arrest situation, entirely analogous to our case. They were aware of the danger or risk of fire if the CS canister was fired, ditto the officers in this case. At letter F of the head note, 1379, you see the police decided they had to arrest the intruder. There's no doubt that it was an arrest case. There was a policy, there were various different allegations of negligence. One was if we use the outmoded policy operational distinction that was fashionable for a while, post-Anns, Rowling and Tuccaro, the whole line of jurisprudence, ending up with Lord Hoffman in Stovin saying the policy operational distinction isn't really any help in deciding whether to impose a duty of care. But in this case, it was a long time ago, it was decided that it wasn't negligent to equip the officers with the ferret, which is a different type of gas canister.
Not to equip them with the ferret, actually, but yes.
Okay, right, sorry. Well, you know what I mean, my lord. The fact that they didn't have it was not negligent.
That's it.
But however, they were negligent in failing to react to the departure of the firefighting equipment that they had arranged to be there, MS 1380, and it was causative of the loss. Our written submissions are in the section between paras 44 and 51, MS 67 to 69. So summing up the significance of Rigby, everybody said it's good law. 59C of Lord Keith, MS 280, as an example of damage caused by positive acts or omissions by the police. It was activity obviously at the core of suppression of crime. So on any view, and this again has to be corrected, it was within the wider understanding of the rule, which can only mean Rigby is wrongly decided, or the understanding that the rule is wide is a historical error, which again needs to be corrected to bring it home to where it always to where it was born in 1988 or 89 as a third-party principle, but it's taken 27 years for Lord Toulson and his brethren to bring it back again. But there is still uncertainty.
It's not so much Rigby, is it? Because no one raised the question of any public policy lack of duty in Rigby. The strength of your point, as I understand it, is that Rigby is assumed to be correct in Hill, Brooks, and the rest.
It shows the incoherence, and I use that word in a very polite way. It shows the lack of rigour, the people who have looked at these cases are at the very top of the triangle. And the reason that they have been forced into a series of entirely unacceptable reasoning is simply because it was felt that Hill was a wide rule. Once Hill is controlled in the way that it should be, the problem disappears because we understand why Rigby was decided in the way that it was, and that's because it was a Positive Act case and a creation of a danger case. Let's look quickly at what's been said in the past about it. In this case, at MS 153, Mr. Justice Arnold disagreed with even the Court of Appeal themselves couldn't agree about Rigby. Mr. Justice Arnold said it was an assumption of responsibility case. Lady Justice Hallett said that it was probably, if it was anywhere, an outrageous negligence case. And the outrageous negligence as a category, you find that Brooks, paragraph 34, volume 1, tab 3, MS 322. Lord Steen, unnecessary to imagine cases of outrageous negligence by the police unprotected by specific torts which could fall beyond the reach of Hill's case, etc. So in fact, he's not, again, this is another misunderstanding and a misreading of what he said. He wasn't seeking to create or argue, as I understand it, for a category of outrageous negligence. He was saying that cases on the margins may well come, and when they do, they'll have to be looked at on their facts. No unanimity there in the same court. If I'm wrong about what I've just said about outrageous negligence, and it does exist, Lord Carswell, in fact, not Roger, Lord Carswell, disapproved of the suggestion that there may be such a category, 280 G2H MS 379. I entertain some doubt whether opprobrious epithets provide a satisfactory and workable definition of a legal concept. I should accordingly prefer to leave the ambit of such exceptions undefined at present. Paragraph 109, volume 1, tab 4. Equally, not an assumption of responsibility case. All of my attempts to try and persuade your lordships in Michael that assumption of responsibility was a useful tool in this, or useful concept in this area, fell on decidedly stony ground. And it can't be said to be an assumption case. That is footnote 43 of our written case, paragraph 67 of Michael, MS 430. And then, not operational, Lord Hope in Van Col, paragraph 79, 274D, volume 1, tab 4, MS, I'm sorry I'm going so quickly, MS 373.
Well, you've only 5 minutes left, so
Yeah. Oh.
make the best use of them you can.
Well, I think I've actually got a bit longer because Mr. Johnson gave me another 15 minutes. I could have 2.5 hours and he could have 2 hours. So I'm cutting down my reply time, I think, to 15 minutes. That's, I mean, I think I've made the point there, I think, about Rigby. It falls within the capital and counties area, and it's plenty outside Hill. An informer, paras 110 to 111, Lady Justice Arden, supplementary bundle, volume 9, MS2, supplementary MS 264, I won't read them out. Paras 110 to 111. Now, Lady Justice Arden was assuming that there was a wide understanding of the rule in those paragraphs, but she warned there against an over-ready application of Hill. And also then flirted also with the exceptional situation category. A few words on El Ghazouli Daf. Well, the next heading of my submissions is the respondent correct in arguing that because duties of care have been denied in positive act negligence cases, it must follow that the general rule covers positive acts as well as omissions and therefore protects the police from negligence in causing personal injury to Mrs. Robinson. And there's a reliance on Brooks, Calverley and Daff. I won't have time to get to Calverley, but my learned friend knows what I say about Calverley, and so I'll reply on Calverley. The proper approach, we say, when looking at these cases is to follow the steps I've already set out. Once outside Hill, you simply apply orthodox principles, and then you go through the incremental process. None of it's revolutionary. I then have a section on Calverley, which I won't have time to go through. Brooks, that narrowed any suggestion that the rule was immunity. Lord Steyne reformulated it in terms of the absence of a duty of care rather than as a blanket immunity. Paragraph 28, Volume 1, Tab 3, MS 320. As per the analysis at 73B of our written case, MS 77 to 78, we say that Brooks fits in with Lord Toulson's omissions analysis. And the reason is as follows. The duties asserted in Brooks, that was effectively to protect him and treat him decently. See paragraph 14, MS 313. They were all omissions. They were purported duties to victims of crime or him as an eyewitness. No analogy to Mrs. Robinson's case at all. Failed to take reasonable steps to assess whether he was a victim of crime and accord him reasonable protection and support. Failed to take reasonable steps to give him the assistance and support commonly afforded to an eyewitness to a crime of violence, and failed to give reasonable weight to his eyewitness accounts. Well, Lord Steyne did not spell out what he thought the core principle was in Hill. That's one of the problems with Brooks, paragraph 30. But he was clear that he said if such a case as the Yorkshire Ripper arose again, it would be the same, if decided in the same way. So the court operated on the assumption that Mr. Brooks would have been traumatised in any event. So it's a failure to confer a benefit case. That's Lord Bingham, paragraph 1, 1497C, MS 308, and Lord Steyne at paragraph 16, 1503E, MS 314. This all fits in with the omissions analysis, which capital and counties, I think, 1031C to 1032B, I think I've taken you to that. MS 633 to 634. The damage that he'd suffered was a result of the criminal conduct of the third party, analogous to the fire, by not treating him with respect, etc., as per the pleaded duties. They were failing to accord him a benefit. They didn't make his position materially worse. They did not create a danger. So Brooks fits neatly into Hill and all of the other milestone third-party cases, Smith, Bank, Cole, Michael.
It seems to have been treated, though, by Lord Steyne as a positive case of positive acts or omissions. So that's how it was put by counsel, paragraph 18. And then at paragraph 32, he says, whereas in the present case, the police directly caused the harm to Mr. Brooks.
In the time I have available, we'll look at Lord Hoffman.
And he says there were 3 cases of alleged positive and direct negligence by the police. And
there's a linguistic argument. Linguistically, one can label something as an act or an omission. The famous example of not keeping a proper lookout, an omission, failing to apply the brakes.
Failing to stop, yes.
Yes, correct.
I mean, you can have a positive act, or you can have an omission. You can label these things in any way.
That's the problem, isn't it? Because what Brooks does show is that the absence of duty however wide it is, extends beyond protecting people from the criminal acts of third parties. That is not what Brooks is about, is it? You may be right that it can be categorised as an omission, although, as you rightly say, lots of things one does can be called either positive or omissions according to which end you come from.
Yes, that may be right, but it's outside the core Hill principle. But there's no liability. There's no liability because of the orthodox analysis that we've already gone through.
Right. Okay.
I mean, the peculiarity here is that the criminal act, which is resisting arrest, is in the nature of things inherently consequential on the arrest, or the attempted arrest, and is entirely foreseeable and indeed foreseen.
Trying to work out if that's a point for me or
I think
against
it's a
me.
point in your favour.
It is.
Sorry, I'm actively and in public dying at the moment, but I will stick to my note and then possibly we'll get somewhere. Just a couple of words on indirect direct, which was again a problem that led to Miss Widdett getting into considerable difficulty with the learned judges below. Paragraph 32, Lord Steyne rejects the distinction sought to be drawn between Hill and Brooks using the direct-indirect dichotomy, something relied on by Miss Widdett below, firmly rejected by the Court of Appeal. We say, for the avoidance of any doubt, to correct Mr. Johnson's mischaracterization of our case, that we do not seek to contend that there's any legal material distinction between direct and indirect acts, insofar as the existence of the duty is concerned. The relevant distinction is between acts and omissions, not who pushed whom, which is the direct-indirect issue. So we say that our case is consistent with Brooks and the Court of Appeal, and it makes, well, that's the point I've just made, it makes no difference who actually knocked her over. And then El Ghazouli Daff, we addressed this at paragraph 73D of our written case. We've advanced, or the claimant there advanced claims on the basis that the CPS's negligent failure to discontinue criminal proceedings at an earlier stage resulted in extended periods of time spent remanded in custody. We say, one, within the omissions principle, since in the absence of any intervention by the CPS, the detention would have continued in any event. Two, there can be no argument that the CPS created the source of danger, the detention in the first place, as there was no dispute that the initial detention was justified. In the alternative, it's a positive act case. And what's evident in Daff is that Lord Justice Steyne did not think that matters were determined or resolved merely by an application of Hill, and that Daff in no way detracts from our approach, and you can reconcile it with Michael. It's an example of incrementalism. And then proposition 6, and I've covered a lot of this already. Justification for the general rule is the long-standing common law principle that there's no liability for omissions. We there have, I read back in Smith and Littlewoods as the basis of it, although it went back further than that. Paragraph 97 and 98 of Lord Toulson. Paragraph 114, again 114, 115 I've referred to. The relevant anchor for it from Lord Gough is at 270G to 271C, MS 1472 to MS 1473. The law might acknowledge a general principle that whenever the harmful conduct of another is reasonably foreseeable, it's our duty to take precautions against it, but up to now no legal system has gone so far. And then there is an explanation, which I probably don't need to go into because it's very familiar to the court, I'm sure, about why there is no liability to act in favour of another. I covered it, I think, at the very beginning of my submissions, the almost philosophical position that you shouldn't divert blame from the real culprit to somebody who has no moral blameworthiness. The law of tort is anchored in many ways in morality. And it's reflected in everything that Lord Toulson said. We rely on my Lord Reid in Mitchell below, MS 1047. One consideration is that it's usually considered worse to do harm than to fail to help. To make anyone answerable for doing evil to others is the rule. To make him answerable for preventing evil is, comparatively speaking, the exception. Oh, that's actually a quote not from
The dictum
Lord
of
Reid.
John Stuart Mill rather than...
See, you thought you could be promoted no further, my lord. It just shows there's always somewhere to go. And then Stoven and Wise, Lord Hoffman, 943G to 944C, Volume 5, Tab 39, MS 1519 to 1520. Sound reasons why omissions require different treatment from positive conduct. I don't have time to read through all of that, but this is the why pick on me famous section, or famous dicta. The duty to prevent harm to others or to render assistance to a person in danger or distress may apply to a large and indeterminate class of people who happen to be able to do something. Why should one be held liable rather than another? In economic terms, the efficient allocation of resources usually requires an activity should bear its own costs, etc. So I will now try and show in the next section, because I've actually got to Proposition 7, which just leaves breach of duty, that this is a negligent positive act, not an omission. So Proposition 7, it's not an omission case. It's outside the general rule. If it is, it's an exception under control or creation of danger. It's only if we're wrong on that, and we say we don't get there, but if we're wrong, and we can't go anywhere incrementally, we then go to Caparo, and we then look at policy. So we rely on the Tafaris and Steele article that Lady Hale relied on in the dissent in Michael, both the 2014 and the 2016 research papers, MS 2696, that's the 2014 article. A is not under a duty, so A, the police, is not under a duty to take care to prevent harm occurring to B, Mrs. Robinson, through a source of danger not created by A, i.e. A. Williams, unless there's an assumption of responsibility to protect from the danger, special level of control over the source of the danger, or the status creates an obligation to protect B from that danger. And then Lord Hoffman again in Stovin, MS 1521, 945C to D. Of course, it's always true that the conditions necessary to bring about an event always consist of a combination of acts and omissions. Mr. Stovin's accident was caused by the fact that Mrs. Wise drove out into Station Road and omitted to keep a proper lookout. But this doesn't mean that the distinction between acts and omissions is meaningless or illogical. One must have regard to the purpose of the distinction as it is used in the law of negligence, which is to distinguish between regulating the way in which an activity may be conducted and imposing a duty to act upon a person who is not carrying on any relevant activity. To hold the defendant liable for an act rather than an omission is therefore necessary to be able to say, according to common sense principles of causation, that the damage was caused by something which the defendant did. If I'm driving at 50 miles an hour and fail to apply the brakes, the motorist with whom I collide can plausibly say that the damage was caused by my driving into him at 50 miles an hour. So, I won't read it all out, but Lord Nichols agreed with that at 938 EMS 1506. So what Mr. Johnson says is effectively, this case, Robinson, is all about omissions. He then takes, I very respectfully suggest, a completely barren point on the way that the language is used as a matter of pleading. And that's paragraph 19 of his written case, to which we say 2 points. First, whilst the course of conduct may include a number of acts and omissions, the key is to determine whether the overall course of conduct was something put into motion or embarked upon by the defendant. So we say this is an embarking case. Second, whilst, of course, many of the particulars of negligence will be phrased as a failure to do something, that's just a linguistic question. So pulling it all together, they decided and did embark upon the arrest. It was a positive act. They created and acknowledged the danger. It doesn't fall within the omissions principle. Even within the context of an arrest, if there are some failings which may be construed as omissions, it's still a positive act case. It doesn't then become a Hill case. Source of danger. I've covered this probably sufficiently. I think Smith and Littlewoods, Capital and Counties, these are all references to the, well, I'll hand this up in due course, actually. The Hartwell case, Para 60 MS 73, and the O'Dwyer case. So then control.
3 minutes.
Whilst...
Burn, 3 minutes.
3 minutes, then the bell goes, right. Control... some cases will entail actual physical control, but duties have been recognised in broader circumstances. That was acknowledged in Couch, Para 81 to 83, MS 2369 to 70. So the exception can apply where there is power to exercise control over the third party to prevent the harm. If such an extension were not possible, well, no, I won't go into that. So the power to exercise control in the current circumstances comes from the momentary control they had over him at the outset of the arrest and the statutory power to bring him under control, Section 24 PACE. The nature of the required relationship between the claimant and the defendant, identified in Couch by Tipping J. Dorset Yacht, we rely on. The particular vulnerability of Mrs. Robinson, they would have seen that had they looked. It wasn't an urgent situation. We've got that from the findings. Velino is referred to. That, however, doesn't assist my learned friend. That's MS 1539 to 40. We say that was a case all about a duty to a suspect. Paragraph 17 of Velino rejects such a duty on the basis that the third party was no longer under the immediate power of the officer. But we have sufficient control. Again, paragraph 81 to 83, Couch. And further in Velino, Lord Justice Sheeman seems to say there appears to have been an acceptance that the utterance of the words, "I arrest you," which must have happened here, constitute the threshold at which control could be said to have been exercised. And in the present circumstances, that threshold
Is that right when he's escaping? I mean, it sounds a bit... the whole problem was that he wasn't under control.
Well, I think I've answered that, and I think I've run out of my 3 minutes. I've always talked myself to death.
You've got the trigger event point. The fact is that the arrest created a foreseeable and immediate reaction on the part of the drug dealer.
No need for control, exceptional control.
All to make the argument.
Say again? Yeah, it's control, it's within the exceptions. So I haven't got time to go there, and it may well be that I don't need to, but I would go on to do my third limb of Proposition 7, which is if I can't get in incrementally into a category, we go into policy, but all of the relevant policy has really been departed from in a series of famous cases that I needn't tell you about. The only policy really that survived the treatment of Michael was the question that there would be inevitably a resource issue. But that's the case in any claim against any public authority, and that was a point made very well by Miss Stain in the DSD case, because I watched that video, and there was an argument about policy with James Eadie talking about the valued and almost sacrosanct principles of the common law, here tort claims, policy, completely wrong. It's been departed from in a whole series of cases involving social workers, teachers, barristers, etc., and I won't repeat them, mainly because I've both run out of time and run out of energy. So unless there's anything else, my lords, my lady, those are my submissions. Before I sit down, I didn't get to Proposition 8. If you need more on Novus Actus and the difference between Dorset Yacht and Smith and Littlewoods, we can give you that. but I can't do it now because I only had 2 hours.
Well, you've got it all written down in your speech,
And I got it all written down.
which you're going to let us have.
Thank you.
Thank you very much indeed, Mr. Byrne. Mr. Lemaire? Mr. Johnson, you have a short amount of time before the short adjournment.
Very grateful. My lady, my lords, my client acknowledges at the outset that the appellant, Mrs. Robinson, is, as is obvious, the completely innocent victim in all of this. She was walking along the pavement in Huddersfield town centre, minding her own business, when she was suddenly and without any notice knocked to the ground from behind and suffered injury as a result. Our submission is that the law gives her a remedy. She has, albeit subject to questions of enforceability, a remedy against Mr. Williams, who was, on the findings of both the Court of Appeal and the first instance judge, responsible for knocking her to the ground. And she has a remedy from public funds under the Criminal Injuries Compensation Scheme. She also, although our submission is that the police here did nothing wrong, she also has in principle a right to make a complaint against the police officers who were seeking to arrest Mr. Williams at the time and to have that investigated under the statutory disciplinary regime. Our submission, though, is that the first instance judge and all 3 members of the Court of Appeal were each correct to find that the appellant does not additionally have a remedy against the police in negligence. And there are 6 principal parts to our submission.
Can I just ask you, before you give us the 6, you say she qualifies for compensation under the Criminal Injuries Compensation Scheme?
Yes.
And is that because she is a victim of a crime of violence?
Yes. My understanding is, my instructions are that she has been awarded, she has succeeded under the Criminal Injuries Compensation Scheme as a victim of a crime of violence, the crime of violence being assault.
Assault? Right.
Assault by Mr. Williams, not by the police, by Mr. Williams. So turning to our 6 submissions. First, and I anticipate uncontroversially, we say the police were here at the relevant time discharging their public function of preventing and investigating crime. Second, and certainly controversially, on the arguments that have been advanced this morning, we submit that when discharging their public function of preventing and investigating crime, the police do not generally owe a duty of care to individual members of the public. That is the rule in Hill and Chief Constable of West Yorkshire. The rule in Hill is, we submit, of general but not universal application. It's not limited to cases where the damage is caused by omissions on the part of the police. It applies also, we submit, where the damage is caused by positive police action. And that responds to a range of submissions that have been advanced this morning. Our third submission, short submission, is that insofar as it was here alleged that the police breached a duty of care to Mrs. Robinson, the operative allegations of breach of duty were omissions rather than positive action. So even if my learned friend is right about the ambit of the Hill rule, he does not. We are within that scope. Our fourth submission is that there is a second, discrete and more fundamental reason why the claim fails, and that is because the direct cause of Mrs. Robinson's injuries was the criminal conduct of Mr. Williams. We agree, of course, that the police failed to prevent him from injuring her, and indeed set in course the train of events that resulted in her injury. But there is no general duty on anybody, including the police, to prevent the criminal conduct of a third party. Our fifth submission is that we respectfully submit that the appellant is incorrect to say that there is a general duty of care not to cause foreseeable physical injury to anybody else. That proposed principle is, we say, too broadly stated, and in the terms in which it's stated is simply not correct. And our final submission is that each of the three members of the Court of Appeal were right to conclude that in this case the officers took reasonable care for Mrs. Robinson's safety. My lady, I turn therefore to the first submission, that we were here concerned with the investigation and suppression of crime. The police, of course, perform many diverse roles, but their core function is the investigation and prevention of crime. That function is carried out not for the benefit of any particular victim or any potential victim. It's carried out in the public interest for the benefit of the public generally. It's enforceable by the law in public law proceedings, and it's enforceable under the disciplinary regime to which police officers are subject. At the relevant time, the police officers were seeking to arrest Mr. Williams. There's no dispute that they had power to do so. That power arose under Section 24, subsection 2 of the Police and Criminal Evidence Act 1984. I don't ask you to turn it up, but it's at volume 5, tab 41, MS 1554. That provision gives a constable the power to arrest anyone who he has reasonable grounds for suspecting of having committed an offence when an arrest is necessary, for example, to establish the offender's name or to allow for the prompt and effective investigation of the offence. You get that from Section 24, subsection 2, read with subsections 4 and 5A and 5E. Here, the reason for arresting Mr. Williams was to investigate the offence, to see whether he was in possession of drugs, and to take him in for questioning. That activity, arresting a suspected offender, is at the heart, we submit, of the police's core function of investigating and preventing crime. That's our first submission, that the police were not here engaged, that the police were here engaged in the investigation and prevention of crime, not in any peripheral sense, and one sees plenty of examples in the authorities of the activities of the police which may be more or less loosely connected with that core aim, but in a very direct sense. This case, concerned as it is with the arrest of a man who was dealing in drugs, is, we submit, a paradigm example of police activity designed to prevent or investigate criminal offending, and the duty that is sought to be imposed, namely a duty in that situation, which is an absolutely routine activity for the police, would have very far-reaching consequences indeed.
What would be the position if a member of the public exercised their right of arrest? Would they, because if they failed to do so, then that would be a pure omission and there wouldn't be any liability. But supposing they did, and they did so in a way which caused some injury, which might be alleged to be negligent, would they have, on your case, the same immunity?
My lord, there'd be, if they directly caused injury by use of force.
Yes, they saw someone was committing an offence, and
Yes.
They said we're going to make a citizen's arrest,
Yes.
and the person made a bolt for it, and the same happened unfortunately, here to Mrs. Robinson.
Well, in that situation, I say no liability. If they are exercising out of public spiritedness a function for the benefit of the public, namely to control somebody to prevent them from committing crime so that the police can arrive and take them away, we submit that no duty is owed. Of course, by their direct use of force, there's the potential for tortious liability and assault and battery, and they would have to justify any use of force. But they are not, in my submission, liable for the consequential acts of the offender. Can I make a start on my second submission, that the police do not, in these circumstances, owe a general duty of care. As I've submitted, the function of preventing crime is carried out for the benefit of the public generally. It's that feature that in large measure drives the law's refusal to impose a general duty of care in this context. There would, we submit, and as is reflected in the authorities, be a conflict between the police's general public obligation to prevent crime for the benefit of the public and a private law duty of care owed to people in the position of Mrs. Robinson. And that is because the imposition of a private law duty would impact on the police's freedom of action to arrest offenders in the public interest. That conflict is particularly acute in cases such as the present, and much more so than in many of the authorities. In cases such as Hill and Smith and Michael, to which I will shortly come, but possibly after the short adjournment, there is arguably, we accept, a degree of alignment between the private duty of care that is there sought to be imposed and the general obligations on the police in the public interest. Because in each of those cases, what was being considered was whether the court should impose a duty to investigate and ultimately to arrest the offender in each of those cases. But here, there is, we submit, a real conflict because the putative duty would conflict with the obligation to arrest. With that introduction, may I just make a very short start on the authorities, starting with Hill itself at Divider 1, a claim brought against my client's predecessor in respect of the failure to apprehend Mr. Sutcliffe before he murdered the daughter of the claimant in that case. And the key point, I'm not going to go through the detail of this, but the key point can be picked up from the speech of Lord Templeman at Memory Stick 286, letter D to E, where he said that the action is misconceived, it would do more harm than good. A policeman is a servant of the public and is liable to be dismissed for incompetence. A police force serves the public, and the elected representatives must ensure that the public get the police force they deserve. And I'm not going to go through Lord Keith's public policy reasons, which you see at Memory Stick 280 between letters, Memory Stick 284 between letters A and G, and not least because they've been refined in the later authorities. But although he doesn't say so in terms, it is, we submit, the same underlying point that drives those principles, namely that the police are exercising a public duty and it would be undesirable to introduce tortious duties of care to individual members of the public. My lady, is that a convenient moment?
Very convenient and almost precisely timed. Thank you, Mr. Johnson. We look forward to hearing from you further at 2:00.